The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon, and welcome to this oral argument before the Kansas Supreme Court. I'd like to welcome counsel and all of those who are watching on our Supreme Court Live channel. In addition, I do want to take a moment to welcome and introduce Judge Lori Moulton Fleming. Judge Fleming sat with us on one case this morning as well, but many of you may not have heard my introduction of her. So I would like to let you know a little bit about her. She has served as a district court judge in the 11th Judicial District since May of 2012. The 11th Judicial District is the three-county district in the far southwest corner of the state, made up of Crawford, Cherokee, and Labette counties. Judge Fleming has taken time from her own docket, which is very busy, to help us out today. So we are very appreciative of that, and also very honored, Judge Fleming, to have you sitting with us today.
Thank you, Chief Justice.
With that, I would now ask Mr. Doug Shima, the clerk of the appellate courts, to please call the 1:30 docket. Mr. Shima.
Thank you, Your Honor. May it please the court. The 1:30 docket for Wednesday, October 28, 2020 consists of one case. Appeal number 120184 in the matter of the care and treatment of Richard A. Quillen, Johnson County, briefs both sides. The appellee petitioner has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counselor, would you please state your appearances for the record?
May it please the court, I'm Assistant Solicitor General Dwight Carswell, appearing on behalf of the state of Kansas.
May it please the court, Michael Barty appears on behalf of Richard Quillen, who is the appellant.
Thank you. Mr. Carswell, you may present your argument.
May it please the court, Richard Quillen is an involuntarily committed sexually violent predator who seeks to be placed on transitional release. The Court of Appeals incorrectly held that in order to prevent that, the state must not only satisfy the statutory criteria, but must also demonstrate that Quillen has serious difficulty controlling his dangerous behavior. The root of the Court of Appeals error was its belief that the United States Supreme Court's decision in Kansas v. Hendricks requires that the same standard be used for post-commitment proceedings as for initial commitment. It's true that Hendricks described the standards at the time as the same, but it never held that they had to be. And in fact, importantly, the United States Supreme Court actually found the standard that was used for annual review proceedings at the time to be constitutional, which is the same standard we have today. So Hendricks actually stands for the proposition that the standard that was applied here is constitutional. The United States Supreme Court's later decision in Kansas v. Crane doesn't change this. Crane dealt only with the initial commitment and held that proof of serious difficulty controlling dangerous behavior is required there in order to distinguish a typical recidivist from a person who is likely to reoffend because of their mental abnormality or personality disorder and is therefore subject to commitment. But by the time after initial commitment, that distinction has already been made. It's already been determined that Quillen is not just a typical recidivist. And so the question in post-conviction proceedings is really whether his condition has changed to such an extent that he's now safe to be advanced, in this case, to transitional release. In other cases, it'll be conditional release or final discharge. And so the state is not and should not be required to reprove the initial commitment each and every year. That's res judicata. Instead, the focus is on whether there's been some sort of change that allows the person to be advanced and released out into the community on some basis. Finally.
But at the point where you get to the hearing, hasn't probable cause been established that a change has occurred, thus the basis for the hearing? And to that extent, aren't the due process interests really fairly aligned between the initial commitment and the transitional release hearing?
Yes, there is. The way the statute is set up is it's a two-step process. The person has to establish probable cause, and then after that, the burden shifts to the state to put on a full trial. Now it's before a judge. In Quillen's case, it was before a jury, a full trial, and this burden at that point is then on the state. to prove that there's not been a significant enough change to make the person safe. In terms of the due process interest, I just again go back to Hendricks and the fact that that was what Hendricks considered and found that the standard that is used today satisfies due process. Crane, again, was about distinguishing, to the extent you think Crane isn't already satisfied, and I'll get to that in a moment, but Crane was about distinguishing typical recidivists from these mentally ill individuals. And again, that distinction's already been made, so it doesn't need to be reproven each year. Going on to our next point, even if Crane does apply, though, it's satisfied by the current statutory criteria. A number of other state Supreme Courts have held that even in the initial commitment process, a separate instruction regarding serious difficulty controlling dangerous behavior is not required, and that standards like Kansas uses for post-commitment satisfy Crane because they show that a person is likely to reoffend because of their mental abnormality or personality disorder, and that tie between those two itself adequately demonstrates difficulty controlling dangerous behavior. And that's even more true when it comes to the post-commitment context, where the way the Kansas statute is written is the person's mental abnormality or personality disorder remains such. So given that it's already been proven that they have serious difficulty controlling their dangerous behavior, the question is then whether that remains such that they're not safe to be placed in transitional release and would likely reoffend. And also the way, oh, did you have a question?
Yes, is that because it's implicit that if you couple those two findings together, the continued mental abnormality and the dangerousness, that it's implicit that there's a lack of control? Is that the rationale of those state courts?
Yes, it is. That if you show that the reason the person is likely to reoffend is not just because they're choosing to reoffend, but because of their mental abnormality or personality disorder that's causing them to offend, that adequately satisfies Crane's requirement.
Because that defines a class that's separate from ordinary recidivism or criminal offense.
Yes, that's what those courts hold. And again, that's in the initial commitment even. I mean, they'd also apply to post-commitment. Now in Kansas, we revised our statute in response to Crane, and it now includes a separate element for initial commitment, so we're not arguing that. But for post-commitment, the same, again, it's even a more compelling argument, I believe, there, because you're looking, it's already been proven that he has serious difficulty controlling his dangerous behavior, specifically, explicitly. And the question is then whether his condition remains such that he's not safe to be placed in transitional release. Finally,
how is the jury to know what remains such means if they're not informed about what the criteria were for the initial commitment? And asked to judge whether those conditions are still remain.
The state would put on evidence of the person's mental abnormality or personality disorder, which happened in this case. The state's experts testified about Quillen's pedophilia and proved that up. And again, these terms are defined in statute, or excuse me, in instruction. So there's, I believe, at least instruction given, at least it's defined in statute, and it could be given. The definition of mental abnormality, it's defined as a condition that affects the emotional or relational capacity which predisposes the person to commit sexually violent offenses. So even the definition of mental abnormality includes, to some extent, the Crane standard within it, without a separate instruction getting to that point.
To some extent, but not clearly. In fact, I think that's why it's taken to U.S. Supreme Court decisions to kind of talk about what does that mean and what is that level of control that's required. Why would we not inform the jury that that is the standard that he must remain at?
I think the jury is informed that the state has to prove, now that the burden's on the state after you get past probable cause, that the person continues to have a mental abnormality or personality disorder, and those terms can be defined such that the person is likely to reoffend. And as the other state Supreme Courts have held, that connection that the jury actually has to find and found here satisfies Crane's requirement. Finally, to the extent if you were to hold that explicit instruction is required, the error here was nevertheless harmless for the same reason, the fact that the jury found that Quillen was likely to reoffend based on his mental abnormality or personality disorder demonstrates the jury must have believed that he has serious difficulty controlling his dangerous behavior. In fact, in Crane, the court talked about Hendricks and said the Crane standard was met there because Hendricks suffered from pedophilia, which is a condition defined to include a lack of control. And that's what Quillen's diagnosis was here. It was pedophilia. Now, he contested that, of course, but the state's experts testified that he continued to suffer from pedophilia, and the jury evidently had to find that they were correct in order to find that the state met its burden of proving beyond a reasonable doubt that he continues to suffer from that mental abnormality. Unless there are any further questions.
Mr. Carswell, does instruction 4 get us there anyway by providing that definition of mental abnormality that patterns the statutory definition? So then, in other words, when the jurors read instructions 3 coupled with 4, does that alleviate those concerns about any nexus that may be required in showing a propensity or a lack of control, emotional or volitional control?
I think it does, yes. The definition of mental abnormality, again, combined with the fact that that causes the person to continue to be unsafe for transitional release and likely to reoffend, those things all wrapped up together, the definitions and the connection between those things satisfies Crane, along with the remain such aspect of it. Unless there are any further questions. Thank you.
Thank you, Mr. Carswell. Mr. Barty.
May it please the court. Hendricks tells us and is premised upon the fact that individuals committed have an annual review at which the original commitment criteria must be proven beyond a reasonable doubt. It's a public safety. It's not really an incarceration, but it's a detention of an individual. And that individual has a due process right to liberty. When the annual review test deletes an element, we seem to be in a situation where he can be held perpetually, even though he doesn't meet the statutory criteria for being committed today. We have a specific element that an individual must have serious difficulty controlling his behavior to be committed. That is an aspect that is essential to his being committed. If he no longer has that difficulty maintaining his control over his behavior, it just seems fundamentally unfair to purge that element from the annual review test. We seem to be changing. We are changing. We're changing the criteria for his continued detention. And the procedure that happened here makes the element that was essential to our defense of the case not relevant now. Mr. Quillen had spent, I think, about 12 years in the center, in the predator treatment program at the time of the trial. He'd had no sexual acting out. He had had no violent acting out. He was complying with the rules. He had completed all of his education classes and all of those things. There were not behavioral issues or sexual issues at any time while he was present in the program. The crux of our defense was that he does not have difficulty controlling his behavior, that he's been able to do it for years. We presented expert testimony to that effect. Dr. Barnett reviewed Mr. Quillen's records of attendance in all of his programs, all the disciplinary records, all those things. There just weren't any of those acting out issues present. So that is an indication that he can control his behavior, and he does control his behavior. The problem in part with this is that the state's experts testify that pedophilia never goes away. So he's got this condition forever. The jury knows that. Once you are established as a pedophile, you are always a pedophile. That does seem to, so that's element number one, that he has this abnormality or personality disorder such that he is not safe to be placed in transitional release. Well, he's got that. He's got that pedophilia. That will never go away. The second element that the jury considered was if he is transitional released, he's likely to engage in acts of sexual violence. Well, we have some evidence.
Mr. Carswell basically suggests that it's implicit in those two instructions that covers the necessary finding that he has difficulty controlling his behavior. Why don't those two instructions implicitly cover your concern?
Well, number one, Crane tells us that those don't, that it is a standalone element. The Kansas legislature has agreed that this is a separate standalone element. But when you look at these instructions, the first one I was describing, he suffers from a mental abnormality or personality disorder such that he's not safe to be placed in release. Well, the evidence is clear. He has been diagnosed with pedophilia. The such that language doesn't establish some separate element that has to be proven. It just reflects back that having that abnormality is such that it's not safe for him to be placed in transitional release. When we go to the next element, that if released, he's likely to engage in acts of sexual violence, we've got statistical data that the state presented, static 99, that Mr. Quillen is moderate high risk for reoffending. That's a static test that all the treatment programs, all the personal improvement in the world does not undo that static 99 result. That's permanent. It is static. It does not modify with his increased enlightenment or benefit from participating in this program. So that doesn't reach the question of whether he still has serious difficulty controlling his behavior. And that's the due process problem. We've got a guy who may not meet the standard for being placed into the program, but he can't get out because the element that he satisfies to defeat an original commitment is jettisoned now. And we fudge with these other rules that just don't nail home the fact that the big question here is whether this mentally ill person, this person who's got this diagnosis, has difficulty controlling his behavior or not. I think that's really a fundamental element in this. And it's unfair not to consider that at his annual release, at his annual review, or if he does a petition for release.
Mr. Bertie, but doesn't the fourth instruction put that squarely at issue, where you're defining mental abnormality as a condition that remains as such that there's a lack of volitional or emotional control? And when read in conjunction with the third instruction, you can't find that the respondent has a mental abnormality without, reading that in conjunction with the definition. Arguably, what is your position in response to that?
Well, the mental abnormality or personality disorder here is pedophilia. And there's nothing he can do in the state's expert's opinion to change that. So he is stuck with that diagnosis. It follows him, no matter how much he improves within the program. And that's the danger of the elements instructions, that they don't separate out that point of whether he can control his behavior or not. That is a standalone element. And if we need that, if the state needs to prove that to detain someone, then they should need to have to prove that at his annual review. The issues are the same.
Well, high to moderate risk of reoffending could apply to any recidivist for who has committed any crime separately from being mentally ill, correct?
Correct.
And so what makes it different in this case is the fact of the mental illness, which is pedophilia. And if by definition that makes it difficult to control, then what is left for the state to show?
Well, the pedophilia definition isn't difficult to control. I think the jury was given and I know the experts testified about what pedophilia is. Great difficulty controlling isn't an element of pedophilia. It's, 6 months of obtrusive thoughts or actions. And then another element is, I think, generally grave distress or acting upon that. The diagnosis of pedophilia itself doesn't deal with difficulty controlling behavior or not. And that's why we think it's a standalone, it needs to be a standalone element at annual reviews as it is at commitment.
So that despite the fact that he is a pedophile, that doesn't necessarily mean he cannot control his behavior, even though it is a diagnosis of difficulty to control your behavior.
Well, the definition of pedophilia doesn't have control as an element in it.
Just
it's
just
in
the sexual preference for children, period.
well, yeah, I mean, it's intrusive thoughts, and then it's taking an action based upon those thoughts or having grave distress. And the problem here is that the actions that give rise to that diagnosis of pedophilia occurred back in 1998, something like that. With the way the diagnosis works, according to the state's expert, once you're diagnosed, you still are a pedophile. So that clicks into these instructions in a way that doesn't reflect his current situation, whether he can control his behavior at this point in time. Now, and we introduced evidence that he can. Our expert testified he saw no current indications of pedophilia. Clearly, that had occurred in the past. It was years ago. But Mr. Quillen has done very well since. There have been no new instances of any kind of sexual or violent acting out. So our evidence was that he can control his behavior. We just didn't have a jury instruction that told the jury that's an important element here that you need to find.
Counsel, can you, if I were a juror, how would you explain to me the difference, the sort of common sense difference between difficulty controlling behavior on the one hand and likely to engage in acts on the other?
Well, here's what it seems to me. The state's experts are telling you that he's likely to engage in further acts of sexual violence based on the statistical analysis. The static 99 makes him moderate high risk for reoffending. The SOTIPS makes him a moderate risk. Those are statistical analyses that tell us about people in this who have this same diagnosis. That's just other pedophiles. That's not Richard Quillen. Let's talk about Richard Quillen and his behavior.
But I guess what I'm driving at is separate from the actual evidence. How would an ordinary juror understand the difference between inability to control behavior and likely to engage? Because it seems to me that likely to engage means inability to control, and the inability to control means likely to engage, that they're entirely synonymous.
Well, unfortunately, likely to engage may include people that doesn't tell us what his mental status is. Some people may be able to control their behavior, yet they go ahead and offend, right? They don't meet the test for commitment, if that's the fact. So, you know, the statistical analysis or something tells us it's likely maybe this guy can control his behavior perfectly, and he chooses to go out and reoffend. As illogical as it seems, that guy isn't really what this program is for. This program is directed for people who cannot control their behavior, not those who choose not. Does that make sense? But I mean, do you understand how I may not be expressing it real well, but the real rationale here is that the program's for people who cannot control their behavior, not true criminals who can control their behavior and choose to engage in criminal violation. And I think that's what makes that ability to control essential.
Counsel, I'm having trouble trying to understand the logic of requiring the same criteria for commitment as we are for the criteria to move from the commitment program into what is really just the next step. This is as I understand it, we're committed, then we go to transitional release, then we go to conditional release, and then we go to final discharge. And so this is a progressive process, right? I mean, I understand that much, right?
Well, yeah, it is.
So, so since this is, anyone in this program, any predator, sexual predator, is still in confinement, going from the main program into the transitional release program. So why would the criteria for admittance in the first place have to be the same? Why can't the state set up criteria that's different to just move to the next level as you're kind of on your way out the door, if you will?
Well, the problem is it removes kind of the right of a jury or a judge now to hear a meaningful petition to move to the next step from someone. And I think Quillen had a right to petition for outright release too. I think everybody has the right to do that at their annual review. He chose not to do that. He wanted to move into the next step.
But I understand if you're trying to just be free of the program, that the state might have to have the burden of showing all of the things it had to show in the first place. But when all we're doing is kind of making a lateral change in the program, as opposed to just outright release, why can't the criteria be different as a matter of logic?
The problem is it's not the program doing this.
No, I understand.
It's him trying to force the program to do this.
I understand that, but the fact of the matter is he's going into a different program by being transitionally released, but he's still in a program. So why can't the criteria to move from one to the other be different?
Because I think he has the right to petition to say, I have succeeded well enough to move into the next phase of this program. To prevent me from doing that, they have to show that it's not safe for that to happen. They have to show that I can't control my behavior. They have to show these elements to prevent me from doing this.
Right, and the jury was asked, the jury had to decide whether he was still likely to engage in repeated acts of sexual violence. You know, is he likely to engage in acts of sexual violence? if transitionally released. So that gets kind of back to Justice Stiegel's question. Why isn't this the same thing in a different context? Maybe that doesn't make sense, but I'm having a hard time not equating what supposedly is required here to what happened.
Mr. Barty, aren't you saying in a way that the static tests, the 99 tests, showing likelihood of recommitting a crime could apply to a sociopath or a psychopath and not sexual predator? Those are, that's a determination based on statistics.
Right.
And the pedophile diagnosis does not necessarily mean that he cannot, it's a sexual diagnosis under the violent predator program, but it doesn't necessarily mean that he cannot control his behavior personally. Is
Right.
that what you're saying?
Yes.
So then if you have the added element of this person is a diagnosed pedophile, and this very person cannot control his behavior in that sexual diagnosis, that necessarily then leads to the likelihood that he will recommit.
Yes, the question is whether he himself has this great degree of difficulty controlling his behavior. And that's unique to him. It's not really based on simply his diagnosis or how he scores on statistical tests. And I think if he shows that, then he is able to progress to the next step against the program's wishes, or perhaps be released if he had petitioned to do that. He just didn't want to do it that way.
Are there other questions? Thank you, Mr. Barty.
Thank you.
Mr. Carswell, you reserve 3 minutes for rebuttal.
Thank you. I'd have 2 points I'd want to make. First, Mr. Barty talked quite a bit about the facts of this case and what Quillen has done or hasn't done. Again, I just want to remind the court that the jury here found beyond a reasonable doubt that the state proved the statutory criteria, including the fact that Quillen is not safe to be released on transitional release, and if so, would likely reoffend. So Quillen on an appeal doesn't challenge the sufficiency of the evidence for those findings. So it's established that Quillen is dangerous. Due process doesn't require the state to release people who are mentally ill and likely to reoffend into the community. The state, as Hendricks held, can continue to hold those people. Second, Mr. Barty talked about Quillen's pedophilia diagnosis and the fact that it's a lifelong diagnosis, according to some of the experts. That doesn't mean the nature of his pedophilia can't change such that he is no longer likely to reoffend. And that's the question. And we're not saying the ability to control behavior is irrelevant to that. It certainly can come into play. A person can argue, well, I can, because of what treatment I've received and what I've learned in treatment, I can now control my behavior and therefore I'm not likely to reoffend anymore. But it's not a separate element. It's not something that you look at apart from that statutory criteria. And the pairing of the mental abnormality with the likelihood of reoffending establishes that. Unless there are any further questions, we would urge you to reverse the Court of Appeals. Thank you.
Are there other questions?
I had one question.
Sure.
So I wanted to direct you to an issue that came up with Mr. Barty, and I think Justice Stiegel initiated it. So when you're looking at the language, likely to engage versus serious difficulty controlling behavior, there's an argument to be made that implicitly one is contained within the other. But if I understand Mr. Barty's position, he's saying despite the similarity of the language itself, the difference is the way these elements would be proven. One would usually be through, statistical analysis like personality inventories and assessments. The other would be proven through observations, behavior. Could you address his argument?
Sure. Well, Crane did say there's a distinction between people who are typical recidivists, that is likely to reoffend for reasons other than a mental abnormality or personality disorder. And the fact that a person is unable to control or has serious difficulty controlling their dangerous behavior is part of Crane, because it's that connection between the mental abnormality or personality disorder, the link to that and the likelihood of reoffending. And so when you have that connection, that itself establishes the serious difficulty controlling dangerous behavior. So they aren't in abstract quite the same thing, but when you pair the likelihood of reoffending with the mental abnormality or personality disorder, it is the combination of those two things. In terms of evidence, both types of evidence are certainly relevant to that question. Because a person is confined, just observing how they behave within the context of the treatment program doesn't necessarily tell you what will happen if they get released. So there are all kinds of tests and things. Mr. Barty referred to the static 99. That's one, but it's certainly not the only test. There are more. That test in particular is, as its name would indicate, static, so it doesn't change much. But there are other tests that are more, the SOTIPs, I think is what one is called, that look at different aspects that do change over time. And you can also look at what kind of treatment he's received, how he's responded to treatment, what he's done in the treatment program. Leading up to transitional release, I don't think he's at that point yet, but they take him on community outings and things and observe how people behave out in the community. So there are a lot of different pieces of evidence that could go into play. But again, Quillen doesn't challenge the sufficiency of the evidence here for his likelihood of reoffending. It's established and is not contested that he's likely to reoffend if released. And the state therefore shouldn't be, or transitionally released. The state therefore shouldn't be required to advance him to transitional release. Unless there's anything else. Thank you.
Other questions? Thank you, counsel. Thank you to both of counsel for your arguments today. The court will take this matter under advisement. We will now be in recess until 9 a.m. tomorrow morning.